platform, we want to discuss with our experts how exactly could a potential peaceful resolution of Russia's wars against Ukraine affected the prosecution and punishment of international crimes. We need to remember that we have a process of negotiation for now. And this process of negotiation not looks like tomorrow it will be finished, some peaceful resolution. That's bad news from one side. From other side, that means that we have a time to discuss how exactly protect all our accusation against the international crimes, because Russia commits numerous, like 10,000 like minimum crimes, which Tribunal for Putin, our initiative, joining together with our human rights defender organization, we documented more than 88,000 potential international crimes. But when we speak about peaceful negotiation, it's always possible, and Russia even tried to put it like one of the points of peaceful resolution, that's about not account the whole the damages and whole the problems which exactly war bring us. And sometimes we can think that Russia dreaming about amnesia for anyone who committed crimes. Sure, international crimes, that's impossible to have amnesia. But when we speak with Russians, we know that rules for them, it's flexible. So how we can protect these needs of international crimes? And so I proposed for our speakers, which I represent now, I proposed to speak about that at the beginning, like till 5 minutes. And after this, I drop some new questions. And sure, we have a time for our audience questions, because it's really important things. From one side, we want a peace. From other side, peace with Russians. It's always can be tricky things. So together with us, Olga Butkevych, president of the International Association of International Law. I hope few minutes will join with us Pavlo Klimkin, former Minister of Foreign Affairs of Ukraine, diplomat and expert at international policy. Yes, exactly in this moment he comes to us. Yeah, perfect timing, please. I'm exactly just to call you. Please join to us. And our speakers, which I mentioned in the morning, because yesterday we have a special side event with them, with her, Agnieszka Bieńczyk-Missala, if I write, professor of political science, researcher and lecturer of the Faculty of Political Science, International Studies of University of Warsaw. And Elena Baylis, professor of law, University of Pittsburgh Law School. Elena, are you with us? Oh, yeah, I see you. Thank you. So I just repeat our topic for Pavlo to have a few moments to brief. So peaceful negotiation from one side, and other side, it's a huge numerous of committed international crimes. And how it can be, these two processes can be combined, and how we can protect international justice, which we need, from other sides, together, combined together with peaceful negotiation. So if I may, we will start with Elena. Yeah, can we start for you? So what kind of risk do you see, and how you think it can be protected, this justice process, international justice process for Ukraine, when we have this international peaceful negotiation? Join not only Russia and Ukraine, but at the table we have USA, we have Turkey, and representative European Union. So how we see this point from your point of view, please.
Good morning. I hope you can hear me well.
Yes, we hear you well.
Wonderful. It's wonderful to be here. Thank you for the invitation, and I'm looking forward to this important conversation. There's so much to say about this topic. And I know that you have some amazing speakers on this panel, so I'm just going to mention a couple of points. If we look sort of historically at peace agreements, they can either promote or undermine international criminal prosecutions in several ways. And so I think that if we think about it holistically, of course, one doesn't want to see the peace agreement affirmatively undermine prosecutions. But because prosecutions can happen in so many different venues, there is a lot of opportunity for prosecutions to happen in some venues, even if they are not then happening in others after a peace agreement. So looking across different kinds of peace agreements, we do see some that actually proactively promote criminal justice and accountability. And so that is something that can be built into a peace agreement, especially if it is something that's made part of the negotiations and there are incentives for that to occur. But even in situations in which amnesties are built into a peace agreement, as was the case in the Minsk I and Minsk II agreements, as you were mentioning, those amnesties don't typically be seen as providing protection against prosecutions for war crimes, genocide, or crimes against humanity. And in addition, an amnesty on the domestic level, I think, can provide actually an incentive for prosecutions in foreign states, which we already see investigations occurring in some states and prosecutions occurring in some states on the basis of the passive personality principle. They can provide an incentive for international courts to take action, and they can provide an incentive for human rights bodies and other bodies to step in. So I think that there's a lot of opportunity across a peace agreement for negotiation in the direction that you'd like to see it go, but also there is a sort of shifting that might well take place, even if a peace agreement is not promoting international criminal prosecutions. The last thing that I'll mention is that if one thinks really broadly across transitional justice and the goals of international criminal law, that there are other mechanisms also that can achieve some of those goals: truth commissions, reparations provisions, claims commissions, and so on, even when criminal prosecutions are not being supported by a peace agreement.
Thank you for your first point. And next, it's really interesting that we know that amnesty traditionally, it's a part of such negotiation. But if it happened, if part of this amnesty can cover someone who commit a war crime, so is it possible? Pani Olha, that's a question for you, if I may. Is it possible that International Criminal Court can accept it like a situation when Ukraine, from status of fully cooperation country, when we have a special law of cooperation with ICC, when we exactly ratify the Roma Statute and all of this process, but we shift to the status of a country who don't want to cooperate?
Thank you. Thank you so much. And first of all, I would like to speak about rhetorics, and then I will go to the ICC. And as well as my audience is mainly, I would like to address Ukrainian audience, so I will go now in Ukraine. We
have the wrong rhetorics about peace negotiations and peaceful settlement. They end the war and just peace. In the movement that started in late 23 and is continuing. The trend is dangerous. At the moment when it started, I posted in a social network. It was a joke, but it wasn't a joke. And I wrote that a peaceful negotiation is possible and not possible, but it's impossible because that the only piece of formula for Ukraine is the 3 R's. That's resumption of control over the occupied territories within the internationally acknowledged borders, then compensation for the damages starting from 2014. And the one we're talking about the International Criminal Court, of course, any amnesty, any avoidance of punishment by international perpetrators who were found guilty committing war crimes and aggression will be direct violation of Ukraine, of international right and its international obligations. In this case, we have an infringement of the Hague Convention, International Humanitarian Law, Geneva Convention, and the Nuremberg Principles that have already have a status of customary law, and they require mandatory punishment that will, of course, be considered not only as Ukraine's refusal or some uncertain position, but direct violation of Ukraine's international obligations. Another risk will be maybe not legal, but political. That's a risk of losing international support, as that pertains to an unpredictable country, unpredictable state. Thank you. But is there any relevant experience for Ukraine when it comes to this kind of settlement where amnesty was mentioned and other such things? Or you don't see anything like that in the history of international law? About Ukraine already had a violation. I remember one, and that was an exchange of prisoners of war, and there was Mr. Tsemich, and he was extradited to the Russian Federation. But there was evidence that he had committed war crime in 2019. He was extradited to the Russian Federation, and the Ukrainian party at that time stated that he got all the necessary, he provided all the necessary testimonies and so on and so forth. But the international law concerned about that person that with grounds, with suspicions of international crime, they have to be judged. It's like, you know, it's like taking testimonies from the Nazi war criminals and letting them go back to South America. About precedents, we talk about the military and political leadership, government of Russia, and the people that committed war crimes, crimes against humanity, and so on. Amnesty might be used. We're not talking about that. The amnesty might be applied to people that took part in the hostilities, that never committed crimes in Ukraine, war crimes, crimes against humanity. But when it comes to humanitarian law, yes, in the light of that, they were engaged in hostilities in Ukraine. Yes, amnesty might be applied for lesser offenses and for harder offenses, but we can talk about amnesty applied to war criminals, international criminals. Today there was a mention of a Lublin Hague Convention on international cooperation in combating international crimes. Ukraine was one of the countries that promoted this convention. Actually, I was one of the first signatories to that convention, and before this convention became effective, this country should not be at odds with this convention. So it says that the state is obliged to detain those people. So we're not interested in examples from history and the actions of other different countries towards war criminals. And yes, thank you.
The English. So how you see all of this process, and we know that 16 point of Rome Institute speak about that if someone speak about amnesty or not like stop to investigate it from Ukrainian side, for example. So Roma Institute speak about that stop the international cases. Yes, so these warrants, which we are really really happy to have, two of them, which commit against Putin, Maria Lvova-Belova, and again the heads of Navy and Russian army and all of this. So if Ukraine we go into such some of these steps, you know, so amnestia or some like not cover some part of war crimes, is it possible that ICC exactly can look at that and say, okay, that's why we are stop our investigation, or not? What do you think?
So first of all, ICC plays a contemplatory role. So a lot depends on what's going on in Ukraine and in Russia in the future. Article number 16 is, of course, a kind of gate to political pressure against on ICC. So from the state point of view, the most important, there are some tasks, some goals, right? To guarantee peace, to prevent future conflicts, and of course to punish serious human rights violations and international crimes. International institutions also are not bound by political situations. So we know in the history there were some examples, for example, Bosnia and Herzegovina, as you know, Dayton Peace didn't include rules concerning prosecutions and punishment, but the International Court was there, ad hoc tribunal. So this peace accord didn't stop the court. But ICC is in a very specific situation, as I mentioned. Also, the case of Sudan shows us that the state itself can somehow stop ICC proceedings. So it is something what we could expect, of course.
Thank you. Пане Павло, до вас переходимо. Хотіла би задіяти
Mr. Pavlo, we switch to your expertise and extensive experience in presenting Ukraine at international level. Ukraine tried to implement different diplomatic mechanisms, including mechanism on establishing both a special register, international register, and special tribunal that was ratified 2 days ago on crime of aggression. We contacted number of countries to apply universal jurisdiction on opening cases in other countries. These efforts can be a bargaining chip that in order to achieve peace, we will kind of cancel our attempts, or shouldn't Ukraine even think about implementing such steps? I want to greet everyone. It inspires me to talk to people who are working in the field of justice and who are supporting basic human values like human rights. As a politician, I am less optimistic, unfortunately, and I will say why. Because we are now going through the process of fragmentation of all present legal and judicial mechanism, ICC, ICJ. Please ask yourself, can we count on ICC or ICJ in anything that will bring us closer to the result we want to achieve? I think that most of you will answer no. Yes, then we created tribunal. On one side, it's a progress that we want to have, because absence of progress is demotivating us. But also we understand that this is further fragmentation of the system, because here we see participation of the European Council, but where all other stakeholders, like, are they concerned about absence of accountability? And that's the frank answer to give. And number three, globally, there are more and more players who consider these law systems not as a goal, but as a tool. And if they see them as a tool, as a politician, I can say that you always can go into interpretation of this mechanism that are favorable to you, and that's kind of it negatively affects existing legal tools. So it means that they're used to close valves here or there, and it means that they more and more or less able to be relevant to the principles they declared. Look, if we talk about any bilateral agreement that will can agree a deviation from the basic international law systems, my answer will be yes and no. On one, I'm a big fan of legal legitimacy of any process. Yes, like, but yes, you can say yes. At some stage, we will get at least someone, and the fact of persecution is, and the fact that justice in war crimes has no expiry deadlines yet. Whether so, but at the other hand, well, if can we reach such agreements bilaterally? Yes, we can. Whether they will 100% violate certain international mechanism, not necessarily, but so we should understand that there is international law, there is a will for the part of international community to promote those mechanisms. But I see this world, and I look at this world, and I see that many countries don't want to extend and want to extend their own rules to different both political and judicial international mechanisms. Yes, so and it will be more than difficult to keep them consistent. We all know that United States has their own position about the mechanism of international persecution. It doesn't mean that they are necessarily bad, but that's their personal viewpoint, and that also creates some interpretation of the established mechanism. So, so I cannot exclude that during the peace negotiations we will have some deviations, but not necessarily they will be against the adopted mechanism, but we should not be like even like these agreements will be on the level of approaches, and like, because we see that United States will partially normalize how they deal with this Russian regime, yeah, and maybe and we have we should be very unbiased in understanding what it will mean for us, depending on the international political reality. Thank you, Pavlo.
question for all of you will be common, and after this I will have after your answers I will have the opportunity to our audience put the questions. Зараз я задам загальне питання, після цього право питання.
I will ask a general question to the panelists, and then I will give the floor to the audience to ask their questions. Please make sure you have used this chance to ask questions.
Zone of negotiation when we speak about international justice. So now most of us, like Pavlo, speak about that we need to have a deal. But we, like a professional of internet, we could have a deal. Yes, but we exactly, like professionals in international humanitarian, international criminal law, we think about, come on guys, rules was writing not to broke them, but we understood that these rules, it's rules of result of negotiation. Most of international law, it's agreements. So what kind zone of agreement, maybe a new agreement, possible in this process between Russia, Ukraine, and all other partners of this negotiation? So, Ms. Olena, can we come to you?
Thank you. So there's a lot of space for different kinds of agreements, obviously, but I think there's been some options that have been explored already. There was a project by Cambridge University that put together a set of options for a settlement agreement and sort of explored how those might play out. So I think that one possibility that might realistically balance these interests of enabling the pursuit of international criminal justice, but also realistically understanding that that the parties, and particularly Russia, might be interested in avoiding some of those prosecutions, is to create a balance between enabling some investigations while constraining others. So there was a proposed framework draft settlement agreement that Mark Weller put out that permitted domestic prosecutions without allowing prosecutions in absentia, didn't stop permanently any ongoing investigations, but allowed for the sort of Article 16 deferrals that you were mentioning earlier, and had a provision that said that the parties to the agreement, including a group of supporting states, would not promote additional prosecution mechanisms. That kind of balance leaves open the possibility of domestic prosecutions, not only in Ukraine or, for that matter, Russia, but also in foreign states under principles of universal jurisdiction, or in a more limited way, passive personality jurisdiction, and doesn't cut off completely the possibility of international prosecutions in the future, while limiting them in the present, conditioned on continued respect for the peace agreement. So it continues to hold out that risk of prosecution in the future if the peace agreement isn't honored, but limits the risk to political figures and others presently. So, you know, there's all kinds of mechanisms that could be used. And as we were discussing, any peace agreement can't in and of itself completely cut off the possibility of prosecutions in other venues by parties not present or not members of the agreement.
Thank you. And Pani Agnieszka, I will come to you because it's a part of, you know, Poland have, for example, used the universal jurisdiction, and it's and Poland one of the really interesting sides to have this peace and protect their territory and their society from opportunities to have aggression from Russia. So how you see it here, where Poland supports some potentially can support some agreement which maybe have a zone for new deal about international justice?
So Poland has quite strict position because we believe that there will be no peace in the future without justice. So since the very beginning, Poland supported all international initiatives to prosecute Russian crimes in ICC, ICJ as well, and on the national level. And since the very beginning of the war, like my position was that this case, Ukrainian case, Russian crimes in Ukraine, will be the best documented crimes, and even if we doubt in international system, international justice, I believe the most important is to be prepared, to define what justice means for Ukraine and for Ukrainian victims, and to prepare national and international framework to prosecute and to punish perpetrators. I know it's idealistic approach, but I believe we need to be prepared for different scenarios. Of course, compromise there is a space for compromise. I believe that, for example, Colombian case could be analyzed by Ukrainians, because in this case, it was agreed to reduce sentences, not to avoid punishments, but to reduce sentences. And it was accepted. Colombian Constitutional Court issued the judgment referring to the right to peace, which is here. It's not legally binding, it's not well legally defined, but in Colombia and also Inter-American Court for Human Rights tried to, some judges refer to the right to peace. And sometimes, of course, it is in conflict with the right to justice. So in Colombia, this kind of compromise was found. So I believe Ukraine should be prepared for different scenarios, but should do everything to be prepared for the best possible solution from the justice point of view, because delayed justice is always possible.
Пані Олі, візьміть, будь ласка, мікрофон. Тож, з таким самим питанням до вас. Де все ж таки ми можемо шукати цей баланс між домовленістю про мир?
The very same question. How we should seek this balance between achieving peace and not making sure that we achieve international justice for war criminals. So yes, agreements are totally necessary, and at least on the level of procedure of return of cultural values, procedures on reparations, and whether we will agree them tomorrow, no. 2 years in the future, no. So currently, Ukraine is benefiting from keeping the status quo. And I want to return to the issue of international criminal justice. Will we prosecute every single war criminal? Definitely no. Never in history there was such a precedent. I want to mention international prosecutor on Yugoslavia, and she said that it's very pity that thousands of war criminals are still walking on the streets of Serbia. That's when the International Criminal Tribunal for Yugoslavia stopped their activities. And similar can be applied to the Ukrainian future. But what Ukraine should do is to utilize all available international, both criminal and non-criminal jurisdictions, in ICC, International Court of Human Rights, European Court of Human Rights, but also Ukraine should extensively use all national tools for prosecution, and because, for example, and internet and foreign jurisdictions too, because there are a lot of foreigners who became victims from this conflict. For example, in Germany, Netherlands, and there were some sentences, and in their countries, national processes are going on. So it's important for Ukraine to collect evidences and proceed in all those jurisdictions. But definitely we should understand this is not the panacea, and it's not realistic to hope that every war criminal will be persecuted. And with regards to the general topic of the event, like when we talk whether there's peace agreement, end of war, whether it will be an obstacle for achieving justice. If the justice won't be in place, won't be part of that peace agreement, it will drastically influence the future of the international justice. For example, if in future we can have wars between two countries of, let's say, so-called third war, why should they stop themselves from committing aggression? Why should they refrain from committing war crimes if Ukrainian-Russian conflict ended without proper prosecution of war criminals? We should understand the possible consequences that such precedent in our case might cause. So for the world. So we should stand on the strong on the positions of international criminal law, because you say that we are leaving, we are example for many other our conflict might be an example for development of many other conflicts. And yes, Ukraine will become a precedent for many other developments in future, definitely. Mr. Pavlo, I want to address you. What we should definitely achieve before we will start to we will end up with hypothetical peace agreement. But we also understand that international criminal justice is not fast. In which areas we should prioritize in order to have them in those mechanisms in place, and to be the strongest when we will end with the peace agreement. I have 3 suggestions. Let's stop them at 3. Otherwise, I will go outside the schedule of the event.
And many people that are in this room can share it, whatever political negotiations or agreements are, or negotiations on them. Just try. If you take every agreement, every sentence, even every word, and I'm not joking, I'm not kidding, every word, try translating that into a legal language from the point of view of obligations, commonly human, and obligations of Russia. There was just mentioned the name of Mark Weller, and that's a very interesting legal expert working in the UK. And he helped at a certain stage, and he achieved certain political agreements, and then they are translated into a legal language. So when they are translated into legal language, there are lots of statements from Moscow that look absolutely gaga. So translating something into a legal language, starting from the UN statute and down to ICC, ICJ, and those modes. The second thing is what we're doing to the registers, to what is going on when it comes to defense. And please do not elevate that. That should be an emotion that will last. If this emotion is lasting, that will be temper, that will go together with some political things that might be might happen, might not happen, but they will happen 100%. And that, to my opinion, in my opinion, a very important story. In other words, we've got to make a way from advocacy, from defense to a systemic statement of what is being done and what will be done. But we also partially construe it from the point of view of our workload, overload. If that's a war crime, that's a war crime, and that's a different thing that should be legally proven, not just politically stated. And the third story is actually very, very simple. In my opinion, we have to keep what we're talking about in the framework of all these international, I would call them legal formats. And then by rules of thumb, we need to explain to the non-Western players why some realities could serve as a precedent, but also maybe like a complicated case. It's very interesting when I talked to representatives of African countries, they say they think about a tribunal to be, and they want to be part of its work, of its performance, to get some experience from the point of view of history, what is going on now and what will be going on the African continent. So they want not actually to study, to learn, but they want to understand, is it possible when it comes to that experience, expertise, can we take it over and use it in our reality? The Rwanda genocide is a different story, but nevertheless, there are certain elements from the point of view of legal interpretations, from the point of view of approaches, where actually those things have a chance to engage with those who find it important, not only interesting, but the story of providing or actually providing for some political agreements. They could be of translating them into the legal language, the language of justice in a way. Yes, it's got its potential, and here the official reality is only part of what could have been done. Thank you. So, dear colleagues, we have our discussion, and now we want to have a common discussion among the floor too. So please raise your hands if you have questions, just for me to get the right bearings. Right. Dear Pani, yes, you're welcome. We have wonderful volunteers. We're very grateful to them. My name is Katerina. I am a defense attorney, and here is my question. Maybe for everyone, yes, because I want an answer from basically from everyone. And today there was a talk about justice, about prosecution of perpetrators that committed war crimes. And we also talked about the fragmentation of mechanisms and modes and regimes. And here is my question. It is obvious right now, currently, that both international criminal law and international humanitarian law cannot prevent war crimes because there is no mechanism for that prevention, that kind of prevention. Do you think, can we, on account of the fact that a conflict could be used for development, so are there any ideas or possibilities or any thoughts on how to realign, maybe reset that mechanism, or maybe create a new one to prevent in the future crimes of aggression, crimes against humanity, and the ones that are recorded in the Roman statute? Okay, thank you very much. We're gonna gather 3 questions to make things more comfortable, and then we're gonna answer. Now, another one. Please introduce yourself.
My question is to all the distinguished panelists. So, so far, Ukrainian government chose to keep issues of justice and accountability off the table during the peace talks to avoid it becoming bargaining chip. This could potentially lead us into a Dayton trap where this issue is not addressed at all. The alternative would be outlining justice and accountability as red lines for Ukraine and insist on Russian leadership being held accountable. But that brings justice back to the table, and we will face two risks. Again, we either bargain about it, or it's going to be a full stop of negotiations, because it's a zero-sum game. So my question is, what do you think about the Ukrainian government position on justice and accountability, and whether you see any alternatives to the risks I mentioned? Thank you.
Дякую. І ваше, прошу, третє питання.
Thank you. And the third question, good afternoon. I'm from the public sector in here, and this is why I've got a question for Pavlo in particular. Yes, and also to everybody. I've heard the three things that you mentioned, but if you were a superhero, superpowers, and you looked at super optimistic scenario for the conflict that we have today, what would you do to improve the situation that we have today? And a question to everybody, what's the role of the public civil society sector? I mean, the way you see it. So what does the civil society have to do to contribute?
How is it, if it's possible, how to rebuild system of humanitarian and criminal law for preventing of war crimes and other international crimes? Third one, what about position of Ukraine state, and maybe exist other risks which Miroslav not mentioned? And third one, Pavlo, for you, it's super, if we have a superpower and can have opportunity maximized scenario, so what we need to do for that, and what role of NGO in all of this? So who wanna take which or mention each of them? Pani Oля, which you like, choose?
Ну, я, напевно, почну з...
I will probably start with on the provision of international law. Can it be done with international law? In the 20th of the last century, there was an aggressive war, and that was considered to be a sovereign right of the state. Aggression was. So, of course, every next conflict will result in an improvement to international law. It will result in progress. Today, we talk about aggression. Today, like that's a crime of crimes. About 100 years ago, that was at the country's discretion. That was absolutely okay for the state. How? Yes, these kinds of efforts are being made, and there are proposals on collective security system to be rebuilt in Europe and also on the international arena. There are conventions that we mentioned in particular, and also the Convention on Crimes Against Humanity, on international crimes. You know, all in all, what we have today on the international law norms, it's okay, it's fine, like banning aggression and not committing war crimes, international crimes, but in practice that doesn't work. So we actually talked about change, not only when it comes to regulatory norms, but practical changes. Without that practical constituent, that won't work.
Actually, I don't know the position of Ukrainian government, but in this context, I would like to ask why peaceful negotiations? Why do we need to pay justice for peace? Why do we need to pay accountability, responsibility of those responsible of war criminals or amnesty to, for example, peace or peaceful negotiations? I don't know the position, the current position of Ukrainian government, but I'm sure that that is not a position to avoid accountability, to avoid responsibility of those of war criminals and of Russian criminals in this context.
Thank you. Ms. Olena, we're going to you, please.
Thank you. Thanks for these fantastic questions. And I think that that all of these questions point to a couple of key underlying characteristics of international criminal law. And one of them is the difference or the distinction between the norms in principle and the ways that they can be enforced. And then the second is the long timeline often of international criminal prosecutions and the long timeline in which justice is pursued and achieved. So thinking about the first and the difference between the legal norms and how they're enforced, as we all know, international criminal prosecutions are few and often arrest warrants or indictments are brought, but then are not actually transformed into prosecutions themselves for various reasons, because the arrests can't be made, because the concerned tribunal runs out of funding. But one thing that does happen is that the very existence of these international legal norms and the decisions by, for example, the European Court of Human Rights, that these massive human rights violations have taken place, enables other actors to take action in other ways, whether it be through sanctions, through isolation, through the end of the EU-Russia visa facilitation program, through reparations, and so on. So I think that when we're thinking about how international criminal law can be used or brought into effect, whether by civil society or in the context of preventing crimes against humanity or war crimes, we're looking at those norms not just as being affected through or put into effect through prosecutions, but also through a wide array of other mechanisms, just because of the reality of the limited capacity of international and national institutions to actually prosecute. And then the second point is that long timeline of international criminal law. In so many instances, we see justice being called for years, for decades, and then eventually coming into effect when the political and social and cultural situation allows for it. And so I think that even when prosecutions are not possible in the moment, sometimes we see them coming into effect many years from now, which of course is not very satisfying in the moment, but presents an opportunity for hope. And I think that one thing that we see happening right now vis-a-vis Ukraine and Russia is the many investigations that are taking place, the collection and preservation of evidence against a point in time when various foreign states, Ukraine, Russia, international institutions are prepared to pursue those prosecutions.
Thank you. And we go into Agnieszka.
Okay, so there is international law, and there are not enough sanctioning system. So in case of such a state as Russia, which uses international law to violate it and to advance in the war, it's very problematic. Like, I believe that from international law perspective, we started all possible procedures. There are sanctions against Russia, and all the time we have the feeling that it's not enough. So, what we could improve in international law, I believe, like observing what's going on in this conflict. I think that there is especially the lack of international mechanism which could somehow monitor the situation on occupied territory, because there is no access, no international institution which could access the territory and at least monitor what's going on there. And I remember that after the Second World War, when the Genocide Convention was proposed by Pavlo Klimkin, he also proposed to have a special international institution which could monitor and deal with all those problems which we face on occupied territories. So this is something which we should start a discussion about it. And international law and respect for international law depends also on the quality of democracy. So my more general remark would be that we need really to save democracy to make international law work. That's why there is a great role of NGOs, civil society, and there is a great role in democratic elections. Because, for example, in Poland's case, I can say that during President Biden's administration, there were like regular consultations between Poland and the United States about prosecution of Russian crimes. And this year, so during President Trump's term, no this kind of meeting, no this kind of discussion. So it's also our role, you know, to maintain this interest of international community about the situation in Ukraine.
Thank you. And, Павло, повертаємось до вас. У вас є навіть окреме.
Coming back to you, you had a personal question. Like if you had that superpower, how you would channel those superpowers to ideally proceed with the prosecution of criminals, war criminals. Like in fragmented world, it's almost impossible. Ideally, and we just were talking about that, any legal system, law system of prosecution should be structured but like in current reality of global reality, it's not possible. So like it's and like to have this blockchain-like structure, and here that we should emphasize the importance of the timeline for considering those international law violation cases. Maybe we can have some preliminary decision which can be voted by like some majority. I don't know. It can be 60, 70, somebody saying about 90, but and like majority of blockchain, and then this like blockchain automatically imposes sanctions, and there is no more need for any additional political decisions, and those who are not imposing sanctions, they've been sanctioned in turn. So such idea had been discussed for some period already, but none of big players are ready to embrace that, because big players they still interested to have this system to be vulnerable to tweaks, and they still interested in functioning of UN Security Council. However, in functional it is now, but they're still interested in having it. And this kind of an answer to the question number one. I don't see now political mechanisms that can force key countries, key legal mechanism to function properly without established enforcement mechanism. So, however controversial would seem the ideas of direct democracy, like like when Elon Musk says how it will be implemented on Mars, but still there is certain inherent logic in that. So having this blockchain-like mechanism of punishment might be a solution, possible solution. But whether it's now implementably taking current reality of our planet, no, it's not possible. But I think future challenges will make us eventually to come with certain solutions. Because if you talk about certain agreements should be later implemented by parties. Yes, like crime of aggression had been described in the charters of UN. It's a backbone of the international criminal law, and that if we within this mechanism we reach certain agreement, yes, there still can be somebody who says no, okay, but I don't think this is a valid decision, because English law has a very great mechanism, duress. So if you prove that in the court, yes, and then you're fine. You can go fine. For example, when we have for example, British legislation is very strict in with regards to following the contract. But if you prove that the contract was concluded under pressure, that totally changes difference. So that's why, like, if you make any agreement which violates international law, and then somebody says, so what? And then that can open this Pandora box. And so that's why if you will hear or be witness of any political agreements, try to immediately translate it into the law, into the language of international law. So, like, because sometimes those agreements, political agreements, will sound nuts, but legally that will be implementable, even in those countries who are not like West, not governed by the so-called Western model. Do we have any other mechanism on how to make ICJ more efficient? I think no. I think they should be rebooted. You cannot cosmetically kind of improve them by some fancy additional tools. I don't see that option, but there are people and even people who I respect even more than myself are still of that opinion. And then let's so I want to go to our final part of the panel, and in a Twitter-like format, can you give your last message to the participants of the event? New feeling, or maybe new understanding of justice can start from us, from Ukraine, with Ukraine, and we should push to that. It won't appear out of nowhere if we don't push for that. The phrase that was mentioned by one of the founders of the International Criminal Law, justice against revenge, and
There is no peace without justice. There is no justice without peace. Be prepared.
Thank you. And Miss Olena, one message from for retweeting, please.
I think the opportunities for international criminal justice, and ultimately even beyond criminal justice, for accountability broadly, are going to continue to carry on into the future, promoted by a peace agreement or in the context of any peace agreement that might come about.
Thank you. Thank you a lot that you was with us today, and let's get applause for all our panelists.
So,